Different modes of talaq and divorce. A Muslim of sound mind, who has attained puberty, may divorce his wife whenever he desires without assigning any cause. A talaq may be effected in any of the following ways. I. Talaq-e-Ahsan. This consists of a single pronouncement of divorce made during a tour period between menstruations, followed by abstinence from sexual intercourse for the period of iddat. A talaq is the ahsan mode becomes irrevocable and complete on the expiration of the period of iddat. I. Talaq-e-Hasan. This consists of 3 pronouncements made during successive tours, no intercourse taking place during any of the 3 tours. A talaq in the Hasan mode becomes irrevocable and complete on the 3rd pronouncement, irrespective of the iddat. Ishi Talaq-ul-Biddah or Talaq-e-Ba'in. This consists of a. 3 pronouncement made during a single tour either in one sentence, e.g. I divorce 3 thrice, or on separate sentence, e.g. I divorce there, I divorce there, I divorce there, or b. A single pronouncement made during a tour clearly indicating an intention irrevocably to dissolve the marriage, e.g., I divorce 3 irrevocably. A talaq is the Ba'in mode becomes irrevocable immediately it is pronounced, irrespective of iddat. Although the power to give divorce belongs primarily to the husband, he may delegate the power to the wife or a 3rd person, either absolutely or conditionally, and either for a particular period or permanently. The person to whom the power is thus delegated may then pronounce the divorce accordingly. A temporary delegation of the power is irrevocable, but a permanent delegation may be revoked. Various kinds of divorce. The various kinds of divorce are as under. Ila. Divorce by ila is a kind of constructive divorce. If a husband, having attained puberty, swears by God not to have sexual intercourse with his wife for a period of 4 months or more, or for unspecified period, he is said to make ila. If the husband, having made ila, abstains from intercourse during the period comprised in the ila, the marriage is dissolved with the period comprised in the ila. The marriage is dissolved with the same legal results as if there had been one irrevocable pronouncement of law made by the husband. I. Zihar. Zihar is a form of inchoate divorce. If the husband compares his wife to his mother or any other female within prohibited degree, the wife has a right to refuse herself to him until he has performed penance. In default of expiration by penance, the wife has the right to apply for a judicial divorce. I. Kula. A divorce by kula is a divorce with the consent and at the instance of the wife, in which she gives or agrees to give a consideration to the husband for her release from the marriage tie. Failure on the part of the wife to pay the consideration for the divorce does not invalidate the divorce, though the husband may sue the wife for it. Vabris mubarat, a mubarat divorce, like hula, is dissolution of marriage by agreement, but there is a difference between the origin of the two. When the aversion is on the side of the wife and she desire a separation, the transaction is called hula. When the aversion is mutual and both the sides desire a separation, the transaction is called mubarat. The offer in a mubarat at divorce may proceed from the wife, or it may proceed from the husband, but once it is accepted, the dissolution is complete, and it operates as a Talaq-e-Ba'in, as in the case of kula. Fau. Lian, the wife is entitled to sue for a decree on the ground that her husband has falsely charged her with adultery. If the charge is proved to be false, she is entitled to a decree of dissolution of the marriage. Divorce under Shia law. In the case of Maryam Bano versus Hussein Ali, it was held that talaq according to Shia law must be orally pronounced by husband in presence of 2 witnesses and wife in a set from of Arabic words.